Our Part 111, 5. Appellate search. 1. Scope of the rules. 2. Initial decision. 3. Board action. Other initial decision. 4. Petition for the reopening. Administrative final actions. 5. Petition for the other relief. 6. Exhaustion and remedies and judicial review. 7. Petition and judicial review mailing address. And 8. Petition and review arbitrational decisions. And 9. Interlocutory appeals. Or scope of the rule: the affiliated of the procedure to apply with the case of the hearing of the required by the Lord, required by the law of the board action that did not apply with the informal manner for the instrument serve with the temporary authority, suspension, special permission of the action, and 82 other matters for the intellectual nature, abandonment of the discontinuity of the proceeding of the issues in Title 49 U.S. Standard Code 10903, governed with a separate affiliated procedure the exclusion of the proceedings. See Title 49 CFR Part 1152. All right, request for the appealated relief and maybe the relate with the initial decision of the board action for the initial decision for the age of the category rules, describe the type of the appeal, with the permanent of the requirements to be observed with the filing of the appeal of the provision, state with the action with the staff, the action with the absence of the stay, appeal of the decision of the employee with each of the acting with the authority of the delegate with the chairman of the board with the pursuant 10, 11, 6, acting with the entire board with the appeal of the must be filed within 10 days of the day of the action by the employee with the response of the appeals must be filed within 10 days thereafter. The appeals are not favored. They will be granted only exemptional circumstances to the correct for the clear error of the judgment, 2 for the prevented manifest of the injustice. 11:15(2) An initial decision. The category includes the initial decision of the administrative law judge of the individual board member or employee of the board. Appeal of the right of the permitted appeal must be based on one or more of the following grounds: necessary finding of the fact with the admitted of the erroneous of the unsupported by the substantial of the aid of evidence for the record, the necessary legal conclusion finding of the contrary of the law of the board president or policy. The only important question of the law of the policy discretion is involved with which with governing the precedent or the prejudicial procedural error that has occurred. The appeal must be detailed with the sale finding of the supporting of the citation of the record of the authorization authorities. Appeals and replies should not be exceeded the 30 pages of the length, with include with the arguments depending on the other attachment, and include with the table of the case for the index of the subject matter. If the appeal must be filed within 20 days of the serve of the day of the decision with any of the further period not to exceed the 20 days of the board may be authorized, and the replies must be filed within 20 days of the date of the appeal is filed. The timely filing with appeal of the initial decision stay with effect over the action depending on the determination of the appeal. G. If any of the appeal initial decision not timely filed with the board does not say effectiveness on the own motion, the award set forth in the initial decision will become the action of the board with the effective date of the expiration of the time filing unless otherwise provided. Alright, section 11:15(3) with the board action and other initial decisions. Discretionary period with the entry of the board action permitted with the scope of the appeal should be designated with the petition with the reconsideration. The petition shall be granted only upon showing with one or more of the following points of the prior action will be effective with the material to be covered with the new evidence of the change of the circumstance of the prior action involved with the material error. The petition must state with the detail of the nature of the reason and the relief of the request of the petition filed with the under this section. The party seeks the opportunity to introduce evidence. If the evidence must be stated with the briefly, must not appear to be cumulative. The explanation must be given why it must be why it is not previously adduced. Petition any of the reply will not exceed 20 pages in length. The separate preface for the summary of the argument not exceeding 3 pages may accompany the petition. Reply with it must be accompanied when they exceed the 10 pages in length. Of the petition must be filed within 20 days after the serve of the action within further period that does not exceed the 20 days of the board with the authority of the following of the petition will not be automatically stayed in effect with the prior for the acting of the action of the board may stay with the effect of the action with the own motion with the non-petition. The petition stay may be filed with the evidence for the petition reconsideration shall be filed within 10 days of the serve of the action. No reply with the be filed with the party to elect for the reply with it must be reached with the board no later than 16 days after the service of the action and proceed the action with the not stay with the will become effective 30 days after service unless the board provides for the action to become effective with a different date with the one on the date the action served the parties may initiate judicial review. Or 11:15(4) petition of the reopening administrative final action. The person any of the time of the file of the petition reopening of administrative file action of the period pursuant with the requirements 11:15(3) with the C and T of this part with the petition reopened. It must be in the detail of the respective in which for the proceeding involved with the material error with the new evidence of substantial change with the circumstances must include the request for the board must be much of the determination. R 1115.5. The position of the relief of the party may petition with the stay of the acting with the pending of the request of the judicial review, the extension of the compliance with the day of the modification with the day of the term of the decision taken in effect with the breach of the desired relief. That must be stayed with the petition. Petition must be filed with no less than 10 days after the prior to the day of the terms of company action taken in effect. No reply may need to be filed. Parties affect the file with a reply, but the reply must reach the board no later than 5 days after the petition is filed. When the term of the board action effective within less than the 15th day of the notice petition staying on the pending of the request of the judicial review must be filed with the institution court action from the close of the serve of the day of the practicable to no reply may be filed whatever the term permits of the party elect with the file with the reply. Petition reply must be exceeded 10 pages in length. All right, 11.15.6. Exhaustion of remedy for the judicial review. These do not relieve the requirement of the party exhaust the administrator of the remedy before going to the court. Action applicable. Any action appealable as of the right must be timely appealable. If the appealable, the discretionary appealed, and petition seeking the reopening of the file under 11.15.2 and 11.15.3 with the part of the before the after petition seeking the judicial review is filed with the courts. With the board will be actions upon the appeal of the petition after advising the court of the pendency, unless the action might interfere within the court jurisdiction. 11.15.7. The petition of judicial review. Petition of judicial review final agency orders that may be served over the board pursuant to Title 28 United States Code 2112A and the address of the General Counsel Office of the General Counsel with the serve of the Transportation Board, Washington, D.C. 20423. All right, the 11.15.8, the petition reviewing the arbitration decision appeal with the right of the board with the permit of the appeal must be filed within 20 days upon the board with the final arbitration decision unless the later date that is authorized by the board is subject to the page limitations 11.15.2 with the arbitration authority with the under paragraph 11.08 with the chapter of the board to stand with the review of the arbitration decision with narrow the relief they only be granted on the grounds that of the decision inconsistent with the sound of the principle of the regulation, economic clear beef, the attributable authority, the discretion incurred with the decision directly based on statutory authority with the board limitation violated with the labor arbitration decision with the board stand with the review and set forth in the Chicago Northwestern Transportation Company abandonment near Dubuque or in Owine, Iowa 3 ICC 2D 729-1987 with the International Brotherhood of Electrical Workers and Interstate Commerce Commission. The timely filing of the petition not automatically stay with the effect of the arbitration decision stay may be requested under 11.15.3. Our 11.15.9 interlocutory appeal with the ruling of the board appeal will include the administrative knowledge of the body may be appealed with the prior to the initial decision only if the ruling denied the terminating of the person's participation. Rules granting of the request for the inspection documentation not ordinarily available to the public inspection. Rules overrule the objection based on the privilege of the result of the ruling requiring presentation of the testimony of the documents. Ruling may request that the substantial irreparable harm substantial to determine public interest undue with the prejudice in part. In standalone case, the compliance with the file under simplified standard of the interlocutory appeal with the ruling shall be filed with the board within 3 business days of the ruling. The reply for the interlocutory appeal should be filed with the board within 3 business days after the filing in such appeal. All other cases of the interlocutory appeals shall be filed with the board within 7 calendar days by ruling, and a reply with the interlocutory appeals shall be filed with the board written 7 calendar days after filing any of such appeals as needed under Title 49-11-047. All right, 11.16 oral arguments. Testing. The